It has been over 30 days since the Lodge Card Club was raided and its assets were seized. Under Texas law, when authorities seize property, they are required to file a civil asset forfeiture in a district court within 30 days of that seizure. Miss that deadline and the property owner has the legal right to get their stuff back. That 30-day window, ticking down from March 10th, expired on April 9th. The initial investigation targeted the lodge on suspicion of 3 serious allegations: money laundering, organized crime, and illegal gambling. The 3 individuals specifically targeted were Jason Levin, Jake Abdullah, and Doug Polk, the club's largest shareholders. The state came in heavy and seized over $2 million in cash and assets. On April 8, the result of the investigation came with a 9-page document filed in the Judicial District Court in Williamson County. The good news was that the state of Texas was dropping the money laundering investigation entirely. The bad news was that the state was keeping the $2 million in seized assets and the illegal gambling case was continuing. The document argued that when the lodge was raided, it was operating in violation of Texas Penal Code Section 47.03 and 47.04, which prohibit promoting illegal gambling and keeping a gambling place. Here's where the story gets genuinely complicated. Gambling is broadly illegal in Texas, but Texas Penal Code 47.04 creates what many lawyers and poker advocates consider a legal defense, which is gambling is permitted if it occurs in a private place, if no person receives any economic benefit other than personal winnings, and if the risk were the same for all participants. Texas poker clubs, including the Lodge, have operated by leaning heavily on this provision. Their argument is simple: they don't take rake from each pot. Instead, players pay an hourly seat fee, which the clubs argue keeps them within the law. But the Williamson County DA is not buying it. The civil forfeiture filing argues that the lodge's owners received economic benefit by charging membership fees and seat fees for the individuals, and by selling food, beverages, alcoholic drinks, merchandise, streaming poker play, and hosting poker tournaments. It further argues that the lodge was not truly private, that it advertised with a billboard along Interstate 35 reading "Play Poker Now," that undercover agents were able to purchase memberships and walk right in without any meaningful vetting process, and that tournaments left money with the house. In other words, the state is saying that any revenue model built around people playing poker, even without a traditional rake, crosses the legal line. The most infuriating part of this story for many in the poker community isn't even the illegal gambling allegations. It's the mechanism the state is using to hold the money, which is called the civil asset forfeiture. And it's a mechanism that requires a shockingly low legal bar to use. In a criminal case, the government must prove guilt beyond a reasonable doubt. But in a civil asset forfeiture case, the government only needs to demonstrate probable cause, roughly defined as more than mere suspicion, but far less than what would be needed for a conviction. The lodge hasn't been convicted of anything, but the state can hold on to $2 million because a judge agreed that there was probable cause that illegal gambling took place. Civil forfeiture laws have been a target of bipartisan criticism across the US for years. Critics argue that these laws allow government to essentially steal from citizens who have never been found guilty and often lack the legal resources to fight back. The irony of this playing out in Texas, a state that loudly and consistently champions personal freedom, limited government, and property rights, has not been lost on anyone watching. The Lodge's case is now one of the most high-profile examples of that dynamic playing out in real time. In September 2025, the city of Dallas spent hundreds of thousands of dollars in a legal battle against Texas Card House over nearly identical illegal gambling allegations and lost. A court ruled that Texas Card House had not violated the state's penal code by operating without taking a rake. That decision was celebrated across the Texas poker community as a landmark vindication of the membership and seat fee model. The Lodge's lawyers will almost certainly point to the Texas Card House ruling as precedent, but legal precedent isn't always clean, and different counties, different judges, and different fact patterns can lead to different outcomes. The Williamson County DA clearly believes the lodge's situation is distinguishable from Texas Card House. Whether the courts agree is another matter entirely. Doug Polk called the March 10 raid a witch hunt almost immediately. As the weeks have passed, a growing number of people have started to agree with that characterization. Think about it. The TABC came in with a full raid, IRS in tow, citing money laundering and organized crime as its justification. Those charges have now been quietly dropped. And yet, the state is holding $2 million and continuing to pursue civil measures against a business that, by any observable standard, operates the same way as dozens of its competitors, none of whom have faced anything close to this level of legal action. Williamson County DA Sean Dick has been specifically called out for what many see as selective enforcement, allowing a World Series of Poker Circuit Series to proceed at Texas Card House in the same county while pursuing civil action against the Lodge Card Club. The question being asked loudly across poker forums is, why the Lodge, why now, and why not everyone else? There are several possible outcomes to this case. The DA could ultimately file criminal illegal gambling charges against Polk, Abdullah, and Levin, charges that, if they ever reach a court, would require the much higher standard of proof beyond a reasonable doubt. The Lodge could fight the civil asset forfeiture and attempt to recover $2 million. The whole thing could drag on for months or even years. And in a broader sense, the legal gray area that Texas poker rooms have operated in for years may finally be headed towards a definitive ruling. Lastly, there could also be the possibility of a settlement. The DA's office might accept some payment or operational charges in exchange for returning some portion of the seized assets and closing the case without a full trial. Settlements in civil forfeiture cases are extremely common, in part because fighting the government in court is expensive and uncertain enough that many defendants simply pay to make the problem go away. For now, the Lodge Card Club sits closed, its future uncertain, its money in the hands of a state that has not been able to prove in a court of law that anyone did anything wrong. Whether this ends as a cautionary tale about government overreach or as a precedent settling crackdown on a legal gray area that's been pushing its luck for years. One thing is clear, the story of the Lodge Card Club is no longer just about poker. It's about what happens when the law is ambiguous, when enforcement is selective, and when the government has the power to take your money first and ask questions later. And for the tens of thousands of poker players across Texas watching this unfold, the stakes have never felt higher.